all across the country. Folks know varying details, so the public is all over the place. They don't really know what transpired recently. So what we can confirm is a judge reinstated Mr. Abu-Jamal's appeal rights in December of 2018. And then in January, your office appealed the judge's ruling that Mr. Abu-Jamal should be allowed to re-argue his appeal before the Pennsylvania Supreme Court. So my question to you, and this is from the general public, because when people ask me about the case, and I am not an activist in this case, so I just, I basically know just a little bit more than what the general public knows. A lot of people are confused about the fact that someone has to appeal to have their appeal rights restored. So can you just talk from a legal point of view, what does that mean? Because a lot of public thinks if you're convicted, you just keep putting appeals in and appeals.
So I cannot actually talk about the details of this case, but I understand that it's an issue of some public interest. So I don't have a problem with talking about what's in the public record already and what is the history here. I just have to be a little careful how I do it. But let me see what I can say. So the case of Mumia Abu-Jamal involves a homicide that occurred on December 9th of 1981. Goes back a long way. Officer Faulkner was maybe 21 years of age, about that. Recently married, maybe less than 18 months. And I say that because his then wife, Maureen Faulkner, has been, she's been in the press quite a bit for the last, 37, 38 years. For a long time. There was a trial. When the trial occurred, the district attorney was not Ronald Castile. This was before Ronald Castile became the district attorney, and I say that for a reason. The United States Supreme Court, in a case known as the Williams case, decided that that in the Williams case, Ronald Castile, who was the prosecutor in Philly and then became a member of the Pennsylvania Supreme Court, had misstepped. And he had misstepped because in the Williams case, he had taken an active and personal role. That's a rough version of language, but he'd taken an active and personal role because he had signed a death warrant for defendant Williams. So the U.S. Supreme Court said that's too much. You can't both have taken an active and personal role in the prosecution of a particular defendant and then sit in judgment on the Court of Appeals in a later job that you have in life. Those particular issues in the Williams case have to be reconsidered by the Pennsylvania Supreme Court. So what is also in the public record is that the Williams issue then, once the U.S. Supreme Court said that, there had to be a looking at a lot of different cases where Ron Castile, sitting on the Court of Appeal, had made a decision, and one of those many cases was the case of Mumia Abu-Jamal. So when that issue came up, it was incumbent upon my office to take a look to see what kind of a role Castile had played. Had he taken an active personal role or had he not? And we followed the guidance of the U.S. Supreme Court. But we did more than that. We actually went through boxes and boxes and boxes and boxes of material to try to see if there's something that we had missed. And we found what was there, and we noted what might not be there, and frankly, found some boxes that hadn't even been disclosed before, and found them very recently. And then we turned them over to the defense, so that the defense would have the opportunity to make their argument. Ultimately, the judge considering the case decided that we were correct, that Ron Castile had, A, not prosecuted the case because he wasn't even the chief prosecutor when it occurred, B, not taken any sort of significant legal action that would show that he was personally involved in a case that would meet the Williams standard. The judge agreed with us. He said, yeah, you're right. But what the judge did, separate and apart from that, is made a decision that in essence said that maybe the standard in Williams was a lot broader than the Supreme Court said it was. Maybe if you've ever been in the district attorney's office, you feel defensive about something the district attorney's office did So maybe there should be the opportunity to rehear these 4 appeals. And by the way, there have been all kinds of legal issues and all kinds of appeals for 30 years in this case. So we're not talking about all the appeals. We're talking about these 4 particular appeals. The judge said that should be reconsidered by the Supreme Court. As we have made clear in filings, if people bother to read our filings, it's always good to read our filings. As we've made clear in our filings, it's an issue if you say that any case that Ron Castile heard, including ones where all litigation was done before he was the DA, have to be reconsidered. That's a real issue for a lot of cases. And, every single case is serious. But that means those potentially thousands of other cases where there may have been strong or weak verdicts are a serious issue too. So the filings say what they say. The filings suggest the issue or issues that we have with the decision that was made by that judge. We have not written our brief yet because the deadline has not arrived. And we will read that brief, and I will hope people who saw that we went and found boxes that hadn't been disclosed and that we turned over those boxes, I would hope that those people would not boil this down to some kind of simplistic comic book about what is really going on. I would hope that they would look at what is in our filings and look at what is in our brief when it is filed before they make their own decision.
Okay.
That's about all I can say.
Well, for the non-attorneys in the room, what does that mean, file our brief?
Okay, so when an appellate issue is raised, when an appellate court is going to consider an issue, essentially they first say, well, what's the question? Tell me the question, and then tell me your argument. The argument is done in writing, and it is presented as a collection of whatever, 30 pages or 100 pages, or whatever it is, and it states your position on the legal issue. So there will be a brief on one side, there will be a brief on the other side, and then the judges will use these 2 arguments to answer the question that is in the case. They're not always brief, these briefs. They can be lengthy.
And so when you filed whatever you did in opposition to the appeal, is that considered prosecutorial discretion?
No, misconduct.
We make decisions in every case, and we try to get the facts and the law correct. And we have to not only look at the individual case, but we have to look at its effects on every other case. And then we exercise our discretion. But it would be a mistake to think that we're flipping a coin, or that we're or that we're making decisions for reasons that are political. That's simply not the case. If that were the case, then there'd be a lot fewer people mad at me. We are making decisions because we think that is what the facts and the law dictate that we should do.